Are you part of a blended family? These days, that's not uncommon. My name is Michelangelo Mortillero, founder of Mortillero Law. We serve clients throughout the state of Florida with estate planning, asset protection, and elder law needs. So let's talk about blended families. These days, around 57% of marriages end in divorce. And that's first-time marriages. I think it's actually higher for subsequent marriages. The problem that blended families can play when it comes to estate planning is that, just like non-blended families, the majority of Americans don't have any estate planning documents. So if you have a traditional nuclear family with, two spouses and two children from the marriage, the states typically will have what's called an intestacy statute that says, where does your stuff go if indeed you pass away without a will or a trust? And usually it goes to the usual suspects. Here in Florida, if all of your children are with your current spouse, you pass away, your assets will go to the current spouse, and then when the spouse dies, to his or her children, which are also your children, and so it goes to spouse and then down to children. That's often exactly what people want. Now, there's still other reasons to do estate planning that has a trust involved in order to avoid probate. There's efficiency for another video. But back to blended families. When you have a blended family, I always give this example. So you have a husband and wife, and they own, it's a long-term, second marriage. They've been married for 20 years. The house is owned jointly. The cars are owned jointly. The bank accounts and non-qualified investment accounts like stocks and bonds, those are owned jointly. With respect to their IRAs and 401ks and life insurance, they have each other as the primary beneficiary. So you get where I'm going with this. If one spouse passes, as far as legally, it's not that big of a deal because the surviving spouse is already either the joint owner or the direct beneficiary on all of the assets. So on the first spouse to pass, not that big of a deal, no probate, everything goes over to the surviving spouse. On the surviving spouse's passing, with no estate planning done, all of the assets, now the marital assets that went over and the individual assets that went to the surviving spouse, will only go to the surviving spouse's children or child. So it inadvertently cuts out the child or children of the first spouse to die. I always give this story, and I think people can resonate to it. So husband and wife, second marriage, 20-year marriage. Husband has 2 children from his previous marriage. Wife has 2 children from her previous marriage. No children together. Now, they're out on date night, and they get in a terrible car accident. Husband dies on impact, and wife dies a week later in the hospital from her injuries suffered during the automobile accident. Where does all the stuff go? Well, husband dies on impact, so everything goes over to the spouse. And so the cars, the home, the bank accounts, investment accounts, retirement accounts, life insurance, you name it, everything goes to wife. A week later, wife dies. Well, everything goes to wife's children. Husband's 2 kids get cut out. You flip the factual scenario, wife dies in the car accident, husband dies a week later, everything goes to husband's children, wife's children get cut out. Now, I have consulted with thousands of blended family couples, and to date, I've never had one family come in and say, we don't really care whose kids get cut out, depending on who dies or first or second, it'll be fine, we're not worried about it. Everybody's worried about it because they want to protect their own family and their own blood, which is their children. So proper estate planning can help you walk through that dynamic of, on the first spouse to pass, we have some options. If we want to leave everything to the surviving spouse to maintain his or her lifestyle, great, we can do that. If you want to take some of your assets and move them over to your children at the time of your death, or if you have a pre or post-nuptial agreement, you could actually move all of your individual assets over to your children and none to your spouse if your spouse has their own assets that they can live off of. Or, back to the first scenario, if you want everything to go to the surviving spouse, then on the surviving spouse passing, with the proper estate planning, we can then compensate both sides of the equation. So husband's 2 children get half or whatever they want, and wife's 2 kids get half, but it doesn't happen until the second spouse passes. All of that needs to be coordinated in your legal documents, or that result will not happen. So if you are the member of a blended household, whether you're the children and your parents are not on their first marriage, or whether it's you and you have children from outside your current marriage, I highly recommend you speak with a qualified estate planning attorney to go through the dynamics and go through the options of how to make sure that you get exactly what you want, the surviving spouse gets exactly what both parties intend, and when both spouses are gone, that all beneficiaries that you deem worthy to inherit some of your assets all get taken care of and no one gets left out in the cold. So we always offer free consultations here at Mortallero Law. I encourage you to do that. We can do them in person, by phone, or Zoom calls. We do represent clients all throughout the state of Florida. So if you or you know someone who is a member of a blended family, feel free to send this video to them. They may find some value, and it may kind of open their eyes to the reality of what will happen if they do nothing with regards to estate planning. Always check our website. We always have both in person, in our offices, educational seminars, as well as webinars. And give us a like and follow for more content. Thank you so much. Have a great day.